I'm very excited to welcome you today to our ELA event, the Environmental Law Association of South Africa. The name of the event is Reclaim the City, a very interesting and topical issue, as you would have seen from the video that you would have watched, the film that you would have watched today, or obviously whenever you have the time to watch it. I just want to introduce quickly, briefly, we have 3 speakers for the event. We have Professor Marius Pieterse from the University of Witwatersrand. He's a professor of law there. We also have Ms. Mandisa Shandu, who's the co-director and attorney at Ndifuna Ukwazi. And we also have Tarryn Cooper-Bell, who's a senior attorney with the Equal Education Law Center. So those are the 3 speakers that we have. Just to repeat, we've got Prof. Marius Pieterse from Wits University, Mandisa Shandu, who is with Ndifuna Ukwazi, and we've got Tarryn Cooper-Bell, who is with Equal Education Law Center. Just a brief bio on the speakers. Like I've said, Prof. Pieterse is a professor of law at the University of Witwatersrand, and his research obviously speaks about issues relating to spatial justice. We also have, like I said, Mandisa Shandu, who incidentally was involved in the Adonisi judgment case, and also obviously has worked with the Reclaim the City movement. Mandisa founded the Ndifuna Ukwazi in 2015, so obviously she's been quite active in this space. We also have Tarryn Cooper-Bell, who's a senior attorney, like I said, with Equal Education, and Equal Education Law Center was obviously involved as amicus in the Adonisi case. So we've got 3 relevant speakers. So welcome to this event. We're very excited to have you here. Just a few housekeeping rules before we get started so that we're all on the same page. I would like to request everybody, unless you're speaking, to mute your mic so that obviously there's no interference when the speaker is busy giving their presentations or when they're answering the questions. Kindly take note for everybody that this event is recorded. So please make sure that if you're going to show your video, that you have a background that obviously you are comfortable with. So please make sure that your background is something you're comfortable with. And obviously, like I said, please everybody make sure that you mute your mics. Just another thing that I wanted to let you guys know is that this event, in terms of the structure, it's going to obviously be an hour. We'll try and keep it within that time. We're going to have 40 minutes in terms of our 3 panelists to speak. And then the last 20 minutes, basically 15 minutes after that, we're going to do a 15-minute session for Q&A questions. Please feel free to drop your questions on the chat box, and we'll record them and then we'll pose them to the speakers. And those who are obviously able to speak via their mics will hopefully allow you to do that. And in the last 5 minutes, one of my colleagues, Ali Petersen, is going to take over in the last 5 minutes just to do the word of thanks. So it's a 40-minute session for the panelists, and then the last 20 minutes we'll deal with obviously the Q&A together with the close of the session. Without much further ado, I would like to hand you guys over to our first speaker, who's going to be Prof. Pieterse, Prof. Marius Pieterse. But before we even get into that, just a brief, just maybe for coherence, you would note that there would have been obviously the film that you would have watched, which speaks about the work that the Reclaim the City has been doing in Cape Town. But as you would see from the film, that their work was prompted by issues relating to spatial apartheid in Cape Town, which, as you would note from the Adonisi judgment, is probably the most segregated city in South Africa. And issues related to that prompted the movement, which is Reclaim the City, to want to move into a particular building, which is in Greenpoint in Cape Town, which is obviously an affluent area of Cape Town where people of color essentially rarely ever stay there. So when they occupied that building, it was more or less a protest, as the Reclaim the City movement was trying to show government that they would want government to accelerate the process of dealing with issues relating to spatial justice and spatial apartheid in Cape Town. And so when you watch the film, you will see that the speakers there and the members of the Reclaim the City movement were trying to advocate and to accelerate the process. And you see that they highlight some of the issues that they've encountered. That as soon as they occupied that building in Greenpoint, which they renamed to the Ahmed Kathrada building, government essentially responded. The Cape Town government responded by switching off the water, switching off the electricity, using divisive tactics like trying to obviously, using like a divide and rule approach where they take some of the members and offer them accommodation, but it is obviously far from the CBD in Cape Town. And as you know, if you note the structure of Cape Town is that it's a segregated city and primarily people of color stay far away from the CBD where the basic amenities that they need are placed. So as a group of people, they occupied, I think there's about 300 of them that occupied that particular building, which, like I said, they've renamed, and it was a way of them protesting. And this occupation obviously was in relation to the Tafelberg site, which they thought would have been earmarked for obviously for low-cost housing for the communities that have been excluded traditionally from the Cape Town inner city. And obviously, as a consequence of that Tafelberg site being allegedly, obviously, trying to with the Western Cape provincial government and the city of Cape Town trying to sell that property to a private school, that obviously prompted the litigation in the Adonis judgment. So when you watch the film, you see they tell you the backdrop of the work that they do, that they advocate for issues relating to spatial justice in Cape Town. They assist communities in Cape Town in terms of advising them if there's any possibilities of eviction and telling them their rights. And obviously the Tafelberg site issue, when the city of Cape Town tried to dispose of that property, prompted them to occupy that building in Greenpoint, which then obviously eventually led to them working together with Mandisa's organization, which is Ndifuna Ukwazi, which eventually led to the litigation in the Adonis judgment. But without speaking too much, obviously we have the experts here. You're all not here to listen to me, but we're here to listen to the experts. So I'll quickly hand over to Prof Pieterse to start over. We have given him a couple of questions that we would like him to have a look at and speak to us about. I'll just reiterate the questions, but I'm sure he's also going to speak about them. But with a couple of questions for Prof Pieterse that he's going to talk about, he's got a few talking points for us. The first question was, what are some of the key observations arising from the film in the context of spatial and environmental injustice and intra and intergenerational injustice? And then the second question was, what are some of the human rights issues arising from the film, and how can they be addressed using litigation such as Adonisi or by other legal means? Prof Pieterse, please take over. I'll keep quiet now.
Thanks, Clive. As Clive just said, my brief was to share some thoughts on Reclaim the City's activities and the short film we watched and the Adonisi judgment in relation to spatial and environmental justice. And I figured if you're the academic on the panel alongside the attorneys and the activists, your job is to theorize. So thank you in advance for indulging me. There are various paradigms for thinking about justice: social, spatial, environmental justice. Nancy Fraser's well-known frame for justice and injustice locates justice in three interlocking dimensions. First, what she calls recognition, which is identity-based affirmation, valuation, and inclusion based in equal moral worth. Secondly, distribution, referring to equitable spread of society's benefits and society's burdens, and of social goods and services, with injustices then to be remedied through either redistribution and, in appropriate cases, restitution. And then thirdly, there's representation, referring to equality of voice and participation. And so thinking of this spatially or environmentally, I would wager requires us looking at an environment, in our case, a city, the city of Cape Town, and considering both within this environment and in its interactions with other interlocking environments, questions of inclusion, of value and voice, of access, and of the distribution of benefits and burdens. And environmental lawyers and development types will add that we need to do this across time, reaching from the past into future generations. And the film clearly shows up plenty subjective articulations of injustice across all three of Fraser's dimensions. There's strong expressions of misrecognition of poor people and people of color, of being banished further away from the city the blacker you are, of not being regarded as good enough to live among the white people in the inner city. There's also patent and lots of talk about maldistribution and lack of access to amenities, services, employment, but also in less tangible benefits or access to less tangible benefits like safety, family life. And several articulations of misrepresentation, of voices not being heard, of only being noticed at election time. And these injustices are articulated in the specific spatial context of Cape Town and also across time. That what I thought was a prize quote from Shanika, a chain of injustice stretching from previous generations through this one into the next if we don't stop it. There are, of course, also other frames through which we can look at the question of urban spatial justice. Most relevant, arguably, right to the city frame, looking at who gets to inhabit and appropriate and participate in and to produce space in the city. More about this later. And secondly, a sustainable development frame. In SDG 11 terms, viewing a just city as one that is safe, inclusive, resilient, and sustainable. And the film leaves no question, I think, that we are dealing here with injustice through these frames as well. So in socio-legal studies, we ask what law and legal institutions can do to address, prevent, and remedy for injustice, and how they articulate with other social institutions in doing so. And then in South Africa, especially, there's a rich discourse on human rights, where we consider what rights, their legal formulation, their litigation, their judicial vindication, their extra-legal everyday performance and assertion can do to advance justice. And assessments here have varied from very optimistic, especially in relation to the famous TAC case and its use of strong constitutional rights, reasonableness analysis, and out-of-court activism in combination to secure major advances in access to crucial healthcare, to assessments that are very pessimistic. Scholars such as Modiri and Tsepo Madlingozi viewing human rights lawyering and adjudication as often being status quo affirming processes that, by referring to losses such as that in the Mazibuko case, or empty victories such as what Grootboom is sometimes perceived to be, and bemoaning that social rights litigation and adjudication in South Africa hasn't really disturbed patterns of inequality, dispossession, misrecognition, maldistribution, misrepresentation, especially for the Black urban poor. And there's been a lot of work done on why this has been the case, and many features of both legal argument and decisions in social rights cases have been pinpointed. Notably, that courts tend to vindicate negative entitlements inherent to rights, to respect existing access to rights, like a guarantee against eviction, far more readily than they elaborate the positive obligations that the rights imply. And that lawyers then, to maximize their chances of winning, of success, then center their arguments around these negative entitlements and obligations. But that the outcome over time of constantly successfully vindicating rights in this defensive manner is that things then stay how they are. And in our context, that people stay where they are and how they've always been. So you win the right not to be evicted from the slum, but that's then where you stay. And I want to talk about the way in which Ndifuna Ukwazi and Reclaim the City's campaign and the Tafelberg judgment, the Adonisi judgment, then begins to transcend this. First, their activism from what I've seen is not just defensive around staving off evictions. They inject this with a positive element of right to the city style production of space by occupying strategic public inner city buildings, appropriating them as spaces of safety, of family life, and of access to urban amenities, and then defending access to that produced space. Secondly, their legal arguments, at least in the Tafelberg case, go straight for the state's positive obligations. And what has specifically excited me has been that they locate these at the intersection of two rights: the right of access to housing and the right of equitable access to land. Now, while South Africa has a rich jurisprudence on the right to housing, after Grootboom, litigation in this space has focused on the guarantee against eviction, to the exclusion of the state's duty to fulfill the right. And while Grootboom mentioned access to land as being entwined with access to housing, the right of equitable access to land in section 25.5 of the Constitution, to quote that the state must, within its available resources, foster conditions which enable citizens to gain access to land on an equitable basis. This right has never really been expressly litigated in this way or in a socioeconomic rights case. And by locating the legal challenge to the sale of Tafelberg site at the intersection of these two rights, Reclaim the City not only forced content into the otherwise quite vague obligation of progressive realization of the right to housing, which in their argument must now foster conditions which enable citizens to access urban land and housing equitably, which is redistribution. But they also highlight that state-owned land is an available resource that must be used in the first instance towards this obligation. And it's so obvious yet so profoundly novel in legal terms that it has even invigorated intergovernmental dynamics around access to housing, both in Adonisi and then in last week or the week before's SABC judgment with the Housing Development Agency and the National Department interdicting a sale of a building owned by the SABC, where the state itself is seemingly now grasping in its internal dynamics and intergovernmental relations platforms the extent of the duty and the obvious resource land that must be applied towards it. Now, as I applaud this interdependence inherent to the litigation strategy and the judgment in Adonisi, I'd like for us to wonder also, given the audience tonight, about how the section 25.5/26.2 combo can be enhanced in this context by also adding the environmental right in section 24 of the Constitution. Now, various scholars, some of which are in tonight's audience, he says nervously, have long lamented that there hasn't really been meaningful articulation between the environmental right and socioeconomic rights. And I've pointed to obvious points of intersection, specifically in the overlapping reasonableness standards between the two provisions and in the potential value of a sustainability frame in considering issues of socioeconomic justice. I've myself argued that if we apply section 24 in an urban environment, it can serve as an entry point for right to the city concerns and can introduce an intergenerational dimension into socioeconomic rights reasoning. And then to go back to the film, Shanika's quote on intergenerational housing and urban access injustice shows us exactly that. Section 24B determines that everyone has the right to have the environment protected for the benefits of present and future generations. And Shanika articulates for us the duty inherent to this right, also with reference to historical injustice, that we must break the chain. But she also links it to production of space by placing the obligation also on people like herself. I quote, "If we're not going to break that chain, it's going to continue. So we amongst ourselves, we have to start to break that chain and to just say no and to occupy." And so the link to section 25.5 is right there, colleagues on the panel, for you to pick up and run with in similar cases. I'm reminded here of another case from Seapoint, the Seapoint for All decision from a few years back, probably about a decade already, where the Cape High Court overturned development permission given to a private hotel to privatize part of the promenade with reference to the need for open multiracial public space as an environmental interest and thereby also a paja right worthy of consideration. Because in a roundabout way, the sale of Tafelberg was also about privatization of public space. And it certainly was on the social function of property, which I think environmental lawyers have a much stronger sense for than they typically get credit for. The other concept then in section 24 that's ripe for the picking here is that of well-being, with the speakers in the film articulating quite clearly how segregation, lack of access, and lack of recognition directly related to their position in the urban environment affects their well-being and that of their families. It's a concept that tellingly has not been given plenty jurisprudential content to date, so I have a sense that it's up for grabs. And then finally, to all the environmental lawyers in the audience, much as I've sort of avoided engaging with you directly because I always tangle myself in your jargon, preparing for this talk, I had to look up twice which one is inter and which one is intragenerational. But I hope that my musings here have illustrated also that in judgments like Adonisi and in the articulations of injustice in this film, there's plenty to work with when it comes to unpacking environmental justice and sustainability in an urban context. And we should all think about it some more. Thank you, that's me.
Thank you very much, Marius. We really appreciate that for setting the scene for us by showing the linkage between, obviously, the lived experience of the participants in that particular film, who are obviously representatives of the Reclaim the City movement, and obviously then connecting that with the law from a conceptual and obviously a philosophical standpoint. I found it quite interesting, the link you made with the environmental right in Section 24, together with how that dovetails together, how it at least complements together with Section 25.5, with obviously the right to property, and obviously the right of access to housing in Section 26. So we appreciate that you have set the scene and you've at least established the theoretical framework for us. And now we will then move on to a session, which is part of this session anyway. We will build on the work that Marius has given us, and we will then have Mandisa Shandu from, obviously, like I said, Ndifuna Ukwazi, and Tarryn Cooper-Bell from Equal Education Law Center. So here we will have a bit more of discussion, and it's going to be going a bit back and forth as we obviously ventilate the issues that arise based on the wonderful introduction that Prof. Pieterse has given us. So we'll start firstly with Mandisa. She will obviously speak first, and then we'll dovetail as we go back and forth with Tarryn. Mandisa, the first question I would like to ask you is, please could you tell us about your work at Ndifuna Ukwazi and what the organization's mission is in relation to addressing spatial injustice? Please go ahead, Mandisa.
Sure. Hi, everyone, and thank you for the invitation and welcome to everybody. I'm really glad that people made the time to join on what's a really cold evening. So to get right into it, Ndifuna Ukwazi is a Cape Town-based non-profit activist organization and law center that combines community organizing, litigation, and research in campaigns aimed at advancing urban land justice. Our primary mission is to expand and protect access to land for affordable housing towards realizing a more equal, spatially just, and inclusive city. Our mission, of course, is informed by, I think, what is commonly understood, or ought to be commonly understood, is that spatial inequality across all South African towns have primarily their historical origin in the colonial and apartheid eras. Throughout these areas, as should be well known, land rights regimes and exclusionary land practices were introduced in pursuit of policies of economic exclusion and absolute racial segregation, aspects of which remain with us today, particularly what is the gross unequal distribution of land. In response to this, Ndifuna Ukwazi, as one of the housing land and housing-based organizations, we have over the past years embarked on a strategy that focuses on Section 25.5 of the Constitution, which centers, as Marius has articulated, the need or the obligation on the state to make land available on an equitable basis. We found this important to prioritize because in as much as the housing work, housing rights-based work that has been done across cities in South Africa is absolutely significant and has brought a lot of shelter and, I guess, protection to thousands of residents across the country. Part of that strategy does seek in some ways to entrench the status quo in that people's access to housing that is state subsidized or is affordable remains on the periphery. And so this idea of integration or inclusivity doesn't happen because land that is in previously actually still primarily predominantly white areas is inaccessible, it's unaffordable, and so the historical colonial and apartheid context remains with us and is entrenched by the contemporary urban land and housing crisis, which of course is a market-centered exclusionary context where people struggle to access land. The state is struggling to address the housing backlog, and the result being that the urban poor lives on the periphery or just unsustainable parcels of land. And so for us, the question is really, how do we give meaning to Section 25.5 of the Constitution, which, as Marius has stated, has been underexplored both in the courts and in practice. And the Tafelberg case, which I guess I'll discuss in a follow-up follow-up question really begins to give meaning to that. I'll stop there for now.
Thank you so much, Mandisa. We appreciate it. As guys, as you would note, that Mandisa obviously was involved in the litigation and the matter. So she was one of the applicants, working very closely with, obviously, with the Reclaim the City movement. So just building on that, we know that obviously the Equal Education Law Center, Tarryn, you guys were also amicus in the matter. Would you mind just explaining to us what Equal Education, how Equal Education Law Center got involved with this Adonisi litigation? And what were some of the arguments that you advanced in this particular matter before we come back to Mandisa to substantiate more on the main case that they argued in the matter?
Okay. Good evening, everyone. Thanks very much, Clive. So the Equal Education Law Center itself is a public interest law organization, and we are a staff of social justice lawyers and researchers who specialize in education policy, legal advocacy, and community lawyering. As well as public interest litigation. And in this situation, we represented Equal Education, who are a democratic movement of learners, parents, and post-school youth who strive for equal and quality education for all learners in South Africa through activism. And so I guess many people are thinking, you know, why would an education-based organization get involved in a case that's essentially around property and spatial injustice? But our intervention really was about bringing the voices of learners to the fore and speaking to how the state's lack of consideration around social housing in the inner city areas of Cape Town really has an adverse effect on the rights of learners. So really how the Western Cape government's failure to provide well-located, affordable housing for poor and working class people actually also has a negative effect on children's education. So in our papers and in our arguments to court on behalf of Equal Education, we really sought to show how the Western Cape government's failure to address we also sought to show how the Western Cape government's failure to address the legacy of apartheid special planning is keeping children from accessing good quality schools and other social amenities. I'll let Mandisa get into this a bit more, but in essence, how we saw this case was that it was about the poor and working class people's right to live, to work, to attend schools in places that are well located and near economic opportunities. We, in our papers, specifically highlighted the negative impact experienced by equalizers. Equalizers are equal education school members, school-going members. And many of these learners are the very self-same learners who are traveling long distances to school every single day. And we highlighted how proximity, living far from the schools that you attend, and thus the impacts of spatial injustice, how those have a huge bearing on a learner's ability to learn. So these learners travel long distances to get to school and back every single day. And this really does come at an enormous cost, not only to the learners, but to their families. And this cost is financial, it's time sacrifices. And in formulating our papers, we also spoke to 13 of the 15 schools located in sort of the inner city area of Cape Town. And these schools highlighted how at least 80% of the learners that attend their schools do not live in the immediate surrounding communities of these schools. And obviously this has an impact on the schools. It has an impact on these learners, and the learners aren't able to assimilate into and benefit from the communities that are surrounding their schools. So yeah, that was just some of the argument that we highlighted, and really what led to our decision to get involved in this case was really to bring the voice of learners to the fore, to highlight that to the judge, and complement the arguments put forward by Ndifuna Ukwazi on behalf of Ms. Adonisi and on behalf of Reclaim the City.
Thank you very much, Tarryn. Mandisa, so can you please just take us through now your work in terms of the sort of the key argument, the key issues that you saw as the ones that you raised before the court. What were sort of the key issues? What arguments did you advance in that respect? And out of that, what are sort of the implications that you see or your insights arising out of the that particular judgment?
Sure. You know,
I know
it's a really, yeah, it's a really hard thing to summarize a case we've been involved in for so long, and one which, you know, the record itself is about more than 8,000 pages now. But there are just maybe 4 things that I think I'll highlight that I think that people listening in tonight can maybe think about in the environmental law work or activism, where the strategies particularly have the potential to dovetail. The first is around outside of the case itself, and I think it's important to emphasize this, is that the campaign to stop the sale of Tafelberg really introduced a new politics, a new kind of strategic way of working for people who have been struggling for access to affordable housing for decades now. This particularly in the context of what would have felt like a stalemate, in that people calling on, asking for, petitioning, and not really seeing any kind of movement or adjustment in the status quo, where land is really at the center of maintaining segregation and exclusion. And so prior to the judgment, there was years of protest, of direct actions, campaign actions by ordinary people, particularly led by women who worked as domestic workers, Miss Mamtozama Adonisi being a care worker herself, really bringing their stories and need to the center. Taking on political power, taking on pockets of power that are sometimes just untapped into, because they are in as much as they're active in terms of, I guess, determining the outcome, they are invisible, this being particularly private property power. And really moving people's stories from the streets ultimately to the system through the legal challenge. So for us, the significance of the case is really one that is about, I really do appreciate the analysis earlier about justice being about representation too. People representing their needs, their calls, their demands in terms of how to give effect to these critical Section 25.5 and Section 26.2 rights. Yeah, I guess really not backing down on what would otherwise seem like an impossible feat. So really taking risks and building, I think, through that, through the movement space and even through the litigation space, relationships of solidarity towards ultimately another aspect of justice being distribution. And related to that, what I think is another important second point that the case has done is it's really centered or focused the question on land. It's a case that is about social housing as it is about access to urban land and how to use tools to unlock it. And those tools being critically legislative tools. And in that thinking, I guess, tactically about how to use procedure as well as challenging the decision through administrative law and really the substantive constitutional aspects, which I think Marius has given us some great context to. And that was so important because I'm reminded of somebody who said in a conversation a few weeks ago that land is power. And without thinking about how to access land, the current systems of power, which we know, have implications for continued exclusion, continued oppression, those remain in place. And so how do we think about power differently towards a distribution of power through access to land? And so for us, that meant, as I mentioned earlier, really confronting the kind of status quo cycle of land being treated primarily or only as a commodity that can be traded, in this instance, by the provincial government for a short-term capital injection to what would have been to a private school, which, by the way, had property just down the road in Camps Bay. But their intention was to sell off this parcel of land, which was the only parcel of land that was available, I guess, for expansive social housing in that area. And, just mindful of the fact that land is finite and it is scarce. Once sold off, it's not something that can be gotten back. and in the context of land being a key mechanism to actually begin to realize distribution. That gave us, I guess, the impetus to call for a different kind of decision making. So back to, the streets, to the system kind of thing, the activism on the ground, really informing and shaping a legal strategy, which is what I'll speak to next. The third aspect, was that the third aspect? Yes, a legal strategy that we knew that we had to, given that there was a vacuum, I guess, in the law in terms of giving meaning to Section 25.5 of the Constitution and what equitable access to urban land means. This was important for us to begin by addressing, I guess, the elephant in the room, which is the most obvious thing. Yes, Cape Town being the most spatially unequal city. And in addition to the spatial inequality, there's obviously a very real wealth inequality too, that also contributes to people's sense of belonging, of being and accessing the city. We challenged in the court case, firstly, that both the city as well as the provincial government hadn't fulfilled their obligation under this section to make land available on an equitable basis, as well as provide the right to housing. And when those rights read together, we'd be able to establish that there's an obligation that exists to use well-located land. So if we're thinking about spatial redress, where the land is located does matter. And the affordability of that land also, I guess, rather the housing of that land also matters if we're thinking seriously about justice and distribution. The court in its August 2020 judgment found in our favor that they had failed to fulfill that obligation, and further that they were required through a structural interdict to work on a joint plan on how they would use well-located parcels of land, not just the Tafelberg site, but other parcels of land in central Cape Town to begin to redress spatial apartheid. The cases, of course, now leave to appeal was granted on that aspect, but that was critical for us to contextualize the issue, which informs the Tafelberg property as one of the few other properties in the area that are suitable for the development of affordable housing. Tafelberg particularly being a parcel of land that had been earmarked years ago for the development of affordable housing, and because of the various dynamics between departments and between different levels of government, this wasn't realized. And I think another important dynamic there is really to shift the idea that market value is the only and the most important type of value, when we know that there's historical value, there's social value, and more importantly, there's a cost. One of, I think, Tarryn's important contribution is that there's a cost in maintaining the status quo. There's a cost including on, as Tarryn said, the right to education for learners who travel long distances and to access education there if they can, and if not, continue to have less quality education. And then just finally, in terms of the other aspects, the case itself, or a large part of the case, was rooted in administrative action in challenging the decision of the Western Cape, the Western Cape's government's decision to sell, to dispose of the parcel of land. And of course, through PAJA and related arguments, we were able to have those decisions reviewed and set aside. But what I do want to emphasize is that strategically, these decisions are, I think, by virtue complex. And so we sought necessary to look at various pieces of legislation that contribute to either A, maintaining the status quo, or B, allowing us to expand on how decisions can and should be made differently. We rooted our arguments in the Constitution, which we've discussed at length, the Social Housing Act being a piece of legislation that's specifically targeted at racial and economic and spatial inclusion, and as well as SPLUMA, which is the source of this obligation, or principle rather, to advance spatial justice. And so the intersection of these various pieces of legislation in addition to those, which I guess are the source of the decision making, being the government movable asset management plan, which says quite clearly that land can't be disposed of if it's not surplus, and if the other departments have got an ulterior need, or rather needed for something else, including for land reform, building, which, you know, building affordable housing would be one of those things, as well as alleviating property, etc., etc. As well as, of course, the Western Cape Land Administration Act and its regulations, which we argued has got it really limits the opportunity for participation, or well, a part of it being I guess an aspect of justice representation, the ability for people to have a say in how public land is used for public purpose, and our interest being housing, but of course so many other public purposes. And I'm sure the environmental lawyers in the room could think of other public purposes where people should have a say prior to a decision being made about how public land is used. The High Court found in our favor on that argument too, but that has been leave to appeal has been granted to the SCA on that because of, I guess, the wide-ranging implications. But if successful, what this would mean is that land throughout the Western Cape that's governed under the Western Cape Land Administration Act, before a decision is made about, you know, the next steps for the use of this land, particularly if it's to be disposed of, the public will and should have a say, and so not an afterthought kind of, rubber stamp type a thin public participation, which I think is great. And I think that there's potential for us to explore other opportunities for public participation in other avenues and really expand on this thin public participation that exists in various pieces of legislation. Yeah, so I think maybe just in terms of the status, the leave to appeal was granted for both the city and the province on various aspects of the judgment, except the aspect relating to the sale of the Tafelberg property. And so that has been, I guess, a concrete victory in that that has been set aside and it won't be challenged up in the Supreme Court of Appeal. I'll stop there for now.
Thank you so much, Mandisa, for a very detailed and very, very well articulated and obviously analytical perspective of the judgment. Obviously, having worked with this matter for a few years, you have incredible knowledge and obviously analysis of the issues. But one of the questions that I was actually going to ask you was, what does this actually mean for the people on the ground, which is what you just answered now, what it actually means. So thank you for that. I think let's just jump into the Q&A. We've got about 10 to 12 minutes to do that. The first few questions relate to the submissions that have been made by Prof. Pieterse. I'm going to just try and go up there because there's a very vibrant discussion that has been happening on the chat box. Prof. Pieterse, I'm sure you've seen some of the questions, but I think the first question that came up, I'll just start with Anel's question for now. Just a couple of questions. Isn't there a risk in cities such as Cape Town, with which have extreme biodiversity richness, that Section 24 might be used as a defense on the part of the state for not performing its obligations, its positive obligations arising from Section 25 and Section 26 of the Constitution? And then the second question is, well-being as a term really only features in Section 24 of the Constitution. Do you think we could make more of it in relation to the quality of life in our cities and the provision of municipal services such as water, sanitation, and even other non-natural resources, resource-related services? And maybe one more question here. How would cities go about it, Prof. Marius again, how would cities go about balancing the environmental rights and protection of biodiversity environment and the social type rights and the positive obligations in terms of Section 25 and 26 of the Constitution? I understand that's a lot to process, but maybe like kept it at 3. If you can just briefly just give us your responses, Prof. I know it's not enough time, but we just try and go through all the questions if possible.
No, thank you. And you started with the one that I have least of an answer to. Anel's question on the state using Section 24 as a defense. I've not thought of that, and I can see that one would run that risk. I mean, the state has used obligations under one right to not give effect to another one before. So my instinct is that, at least in sort of right to the city terms, which is about the kind of places that we produce, so that the conditions and inequities for poor people is precisely what renders an environment unsustainable. And so you fail in your obligation to protect the environment precisely when you fail to protect people, to the extent that they are then forced to subsist in ways that threaten or put stress on biodiversity and so on. So, I mean, but that's a retort to the state. I don't think that really answers Anel's question, but I will cop out in that manner. On well-being, yes, I think so. It kind of links to my previous answer, I hope. For me, in urban environments in which water and sanitation services and so on are substandard, and in which living conditions are dangerous and so on, impacts on well-being in Section 24. As well as to render development sustainable more broadly, as the lady Elizabeth in the film says, when she speaks of safety and fear and compares the environment on the outskirts to the environment in the inner city. I think well-being is the interest that ties those kind of claims together. But the experts on well-being in Section 24 are elsewhere. I am not them. Marisal's question, I think legally it's tricky, and so that's why we must think of Section 24 more than we do in this context, because I think concepts like well-being and intergenerational equity and sustainability in Section 24 give us far more sort of leeway and legal space for striking these balances that are much more sort of receptive to the kinds of questions you speak of than if you just look at, say, Grootboom reasonableness or Section 36 proportionality. For cities, I think what your question was focused more on cities. For them, I think it's tough. I think we need to think more of the kinds of tools we give them and how they use them, you know, to view an impact assessment as something that helps rather than as something that burdens the city in giving effect to its obligations, and to work on developing more appropriate land management and zoning kind of tools that allow for this and so on. Yeah, that's me, Clive.
Thank you very much. Thank you for cutting through the issues. I appreciate it. Tarryn, just to go back to just maybe a couple of questions, I'll give you a couple of minutes just to go through them. But the first thing is I just wanted to ask you, just touch on what Mandisa was talking about. What do you see as sort of the implications of the judgment in terms of for the people in the film? If you can briefly, and out of that, also building on that, what is this issue that they keep referring to as affordable housing? Do you mind giving us your insights based on the work that you guys did in this case, and what is your insight on what does affordable housing actually mean within this context? Thank you.
Yeah, so I mean, in relation to the film, it's families that are affected. It's families that are affected by the lack of social housing within the Western Cape. And obviously, a number of those families have children. And yeah, I mean, I think one of the members in the film was speaking to the fact that traveling it's too far to travel to work, living on the outskirts of Cape Town, and that's, you know, the same implication is on the children who travel too far to school. So I think what the members of or the panelists on the film were saying is really an indication of how families in general are just affected by spatial planning and spatial apartheid within the Western Cape. In relation to affordable housing, I mean, obviously the term affordable, many people think straight to the fact that it's housing where people can afford to live. And that's something that we've had to explain a lot to our equalizers, is what does this concept of affordable housing mean? And as I've mentioned already, it's access to economic opportunities. It's the choice that parents have as to what schools to send their children to. Those all add to this concept, I guess, of affordability that one could have. It's not just this monetary concept, but then also the monetary part of it being that, people having to travel far to work, learners having to travel far to school. As I've mentioned, those economic impacts and those time impacts, the fact that parents can't get involved in their children's education as much as they'd like to, those all have an impact. So yeah, I don't think I'm answering your question completely, but in terms of this affordability aspect, what is affordable housing? It's all of those aspects. It's really just this allowance and allowing families to live in areas that open up opportunities to them.
Thank you, Tarryn. Just as a follow-up, do you think that the environmental right could play a greater role in litigation strategy, especially from the perspective of pursuing intergenerational justice for children?
Absolutely. So we see environmental law playing out in a number of our cases, not only in this Adenisi Tafelberg matter. We see it in a number of our infrastructure matters. We see it in our scholar transport matters. We see the importance of the environmental impact on schooling in playing out in so many different ways. So yeah, certainly that relationship is becoming more and more clear to us.
Sorry, Tarryn. Can you guys hear me?
Yeah.
Yes.
Oh, okay, sorry. Thank you very much, Tarryn. I think just to close off then, a couple of questions for Mandisa. Mandisa, you'd really done an incredible explanation of the issues that arose in the case, how the court dealt with it, and sort of the implications on the ground. But maybe just a couple of follow-up questions which probably suit you the most in terms of what do you view as affordable housing in your experience? In the work that you've done, and maybe secondly, responding to the questions that I think Marcel and Mohammed asked. Well, if you notice from the judgment, there's sort of a reticence from government to sort of in the matter to be sort of actively involved in resolving this matter. We understand obviously there's issues related to the concurrent authority and how the constitution views the role of government and provincial government in that respect, and indeed municipal government. But just what do you think was sort of the reason why the government seemed very reticent to sort of get actively involved? And secondly, how do you see affordable housing? What is the meaning of that within that context? Just to close off the discussion.
Sure. I don't think I quite understand the first question. You mean their reluctance to get involved on which aspect?
Well, the question that was asked was in respect of government doesn't seem to. I mean, people would have thought government would have been sort of more robust in its ability in pushing the agenda of distributing the land, or at least making it available, not having regarded as surplus land. So it seemed like you could get this feeling throughout the judgment that government took the approach of more, I don't know what you call it. They followed, they're very technical about it, or let's use this, the Intergovernmental Relations Framework Act, rather than actually being very robust in engaging with the provincial government and resolving the issue on the ground. But we've got maybe a couple of minutes, and then we'll move on to Ali to just do the closing.
I'll try to be quick with that answer. And I think that at the heart of this is the problem that land in our context has been highly politicized. When it is a resource that really, if treated or approached rather than the way that, for its potential, we could have had so many different results by now. And that politicization, if that's a word, of land contributes to how it's held and viewed as I mentioned earlier, an economic market value or market-centric thing only. And I don't think it's, and a big part of it is, of course, an ideological perspective that's informed by, certain politics and neoliberal politics that sees land and property and housing as commodified goods. And so really what we're calling for is to remove land from that ideological perspective to something else which we feel could contribute to a different urban landscape. And that we had to go through the court to get somewhere is telling. And it's telling that, you know, outside of this, there wouldn't have been a shift. Land in central and other well-located areas of Cape Town haven't been, you know, distributed. And I think that political ideology is a big part of it. On to the other question quickly. I could go on to the with that for a while, but I see we're almost done. Affordability, that's a tough one. It's a tough one because, you know, you could arrive at a different question, a different answer depending on who's asking and our context, but maybe just for some insight. In Cape Town, according to the Center for Affordable Housing Finance, the average sale price for a home in Cape Town at the beginning of 2020 was about 1.5 million, right? So that's the highest in South Africa. And it's a price that less than 5% of the households can afford. And this has obviously gotten so much worse in the context of, you know, COVID and people losing their jobs, et cetera, et cetera. So my personal view is that our understanding or conceptualization of affordability really needs to be responsive to an understanding of the context of inequality that's deepening. In 2019, the Stats SA survey found that a majority of South Africans have a monthly annual income, of about 13,000 Rand per year, which is roughly 1,000 Rand per month, right? And these are people who are employed. There were so many more who are unemployed then and so many more now. And if we, I think, need to confront the reality of people's experiences to understand actually what can and can't be, what isn't affordable. So if the Social Housing Act, for instance, provides that the housing bans are from people earning from 3,500, for some people that might seem like an affordable kind of ban, and they would pay 30% of their of that 3,500, but the reality is a majority of South Africans aren't even earning that much. And so I think that we have to confront a serious reality that's a result of our economic situation, where people aren't affording a lot. And I think in addition to land distribution, other resources also need to be looked at for distribution towards really, I think, lifting us up from what's a looming crisis.
Thank you very much, Mandisa. That was very erudite. We appreciate it. I'm going to hand over to Ally. Ally, please don't kill me. I know I promised to give you 5 minutes, but hopefully you'll be able to do what you need to do within the last couple of minutes. I owe you 3 minutes for the event.
Absolutely.
Ally, please take over.
Of course. Well, before we get into the proper things, a bit of a shameless plug. For our members, one of the perks is being eligible for our giveaways. So we asked everyone the question, why spatial justice is important in South Africa? And one of our members, Bronwyn Gumba, is today's winner with her answer, which reads, the country's history of segregation and the current factors such as poverty, inequality, corruption, and a global pandemic, which has exacerbated the social injustices, spatial justice is an important aspect of ensuring democracy and equity and true transformation. It is a way in which social justice can be achieved. It partially addresses the issues of unequal distribution of material resources. Sorry for butchering that, but it was an amazing, but we'll get to your thank you in a bit. Bronwyn, you'll be walking away with Marius's book about spatial injustice or spatial justice, and that's entitled Rights-Based Litigation, Urban Governance and Social Justice in South Africa, The Right to Joburg. And another shameless plug, if you want to get Marius's book, you can for just 647 Rand and 29 cents. And we'll be sharing all on our website all the great reasons you guys gave for why spatial justice is important in South Africa. So please go check out our website for all of those. And then if you want to keep up to date with these and similar awesome perks. And then if you thought this conversation was worth sharing, which I certainly do, then this recording is available on the YouTube channel, on the ELA YouTube channel. So please go and check that out and share that when that becomes available. Now onto the proper things. I promise we'll keep it short and sweet. It's already 8 o'clock. Clive, you owe me 3 minutes. So for our speakers, Marius, as an academic myself, I appreciated your theorizing about litigation and around spatial justice, and the examples you used really gave some pause and kind of set off a bit of a flurry of comments and questions. So thank you for that. And then Mandisa, thank you so much for your intro to Ndifuna Ukwazi and your interesting insights into the matters you grappled with while assisting the Reclaim the City movement were incredible. And of course, the challenges that you brought to our attention, spatial redress, spatial distribution, really a lot of food for thought. So thank you so much. And then of course, Tarryn, our last and absolutely not the least, your work with equal education as amicus in this case was something that I had never considered before. So in your presentation today, you really showed us kind of the broad impacts of, or broad negative impacts of spatial injustice, and especially around learners in education, which is something I didn't think, but when you spoke to it, it seemed like such an obvious example. So thank you to all of you as presenters. You guys have done an amazing job tonight. And then of course, thanks to our wonderful host, Clive. You did an amazing job facilitating tonight. And then of course, our organizers, Mel and Kate, they organize these streaming clubs just about every last Thursday of every month. So I'll tell you about our next session in a bit. And then of course, thank you to Peter and the ELA Exco who are here tonight. I see quite a few of them in the audience. And then lastly, thank you to the audience. You guys are amazing, both ELA members who are here and friends of the ELA alike. We really appreciate you guys being here. And please join us next time on the 24th of June for Seaspiracy, where we'll be having another absolutely amazing conversation. So thank you, everybody.